Morning, good afternoon, or good evening to everyone, and welcome to all of you at this last session of our AI tech and policy talks of this year. It's a great pleasure for me to welcome all of you for this very special edition of our AI TPT series. For those of you who are not familiar with AI TPT is a series of webinars that we have launched when we kicked off the activities of the Digital Law Center, which basically have the ambition to offer a forum for discussing informally cutting-edge AI tech and policy issues. And today we have the great privilege to welcome Professor Mira, Burri, and Dr. María Vásquez Callo-Müller, both from the University of Lucerne as our distinguished speakers for this session. And they will talk about the very hot and important topic of international IP in the age of AI, implication for digital trade governance. And I will give them the floor in a few seconds. Before doing so, just to let all of you know that what somehow constitutes the DNA of a AI TPT series is the fact that we also welcome distinguished commentators who basically react and comment on the presentation that will be made shortly. And today, it's also a great honor and privilege to welcome two highly distinguished and prominent scholars, Marketa Trimble, who is Professor of IP and co-director of the IP Law Concentration at the University of Nevada in Las Vegas, presently in Europe. Thanks very much, Marketa, for joining us. And Tony Taubman, former director of the IP Government Procurement Competition Division at the World Trade Organization, and now current director of International IP PTI Limited, and who joined us from Australia in the middle of the night. So many thanks, Tony Taubman, for joining us today. So after the presentation, after the comments made by our two distinguished commentators, we will open up the floor for discussion, and please feel free to intervene if you have questions or comments along the way, either by raising your hand or by putting them in writing in the chat function, and we'll take them into account if time permits. So with this, I now want to give the floor to Professor Burri, but I just wanted to say one more thing, or two more things, to be more precise. One is to draw your attention to the fact that the session is recorded and that we plan to make it available on the Digital Law Center website after the session. And the other thing is that I would kindly invite all the participants, to the extent feasible, to please turn their camera on, which is more pleasant for our speakers and commentators. With this, I now turn to our speakers, and I turn the mic and the virtual floor to Professor Burri, with my thanks and gratitude for their presentation, as well as to María Vásquez Callo-Müller. Thank you. We don't hear you, Mira.
Now?
Now it's working.
Okay, all right. So I start again then, and good afternoon or good morning to some of you, and many thanks to Jacques for and his team for this kind invitation, as well as to the very kind introductory words. We very much appreciate being part of this edition of the AI Tech and Policy Talks, which in themselves are such a great initiative to foster discussions around digital law and policy. So as Jacques mentioned, today Maria and I will be discussing the interplay between digital trade governance and intellectual property in the age of artificial intelligence. And this topic was really very much inspired by the work of Professor Marketa Trimble and her comprehensive analysis of TRIPS Plus commitments that we have in the body of regional trade agreements, And she published this article in a 2002 edition of the American University Law Review. That's why we are very happy and really thrilled to have Marketa as our discussant here today, and to have her insights really on sort of the evolution of the global IP regulatory landscape. Our sort of view on things, of course, on recent developments and trends comes from the digital trade rulemaking corner. This is where we have our competences, as you may know, or some of you may know. For the past 5 years or so, we have been exploring all free trade agreements since the year 2000 that deal in some way with digital trade regulation. As you may know, for this purpose, we have also created a data set, Taped, which is called Taped, which collects this information and analyzes this data across 130 different coding items. And some of those deal with topics that are sort of core digital trade topics, as you can imagine, you know, cross-border data flows, digital trade facilitation, non-discrimination of digital products. But the data set actually also covers intellectual property, and that's why we see certain developments or certain disconnect, as we will be showing you today. And by the way, this data set will be updated, and we'll be publishing tomorrow the new edition of the Taped data set, so you can see what has actually happened in the year 2024. So what we can see actually coming from this data, what we can distill in terms of sort of conclusions, is a trend that is especially sort of discernible in recent years, that essentially all agreed upon new treaties, new free trade agreements, be it of bilateral or regional nature, deal squarely with digital trade. So even though we see that less number of agreements have been agreed upon in recent years, the spike of digital trade provisions in those agreements is clearly seen to be observed. And what is also interesting is that these digital trade commitments and provisions, they are no longer scattered throughout the whole treaty, but really become concentrated in digital trade chapters. And these digital trade chapters also become denser in the sense that they have more and more provisions, and these provisions also become more and more binding. And the spike here really is clear in the past 5 years. So you can see that in the new edition of Taped, the dedicated digital trade chapters are more than sort of the majority of the concluded recent PTAs. What is of course important is to see how the geopolitics, who is really participating in this digital trade rulemaking in this very dynamic landscape. And what we can see here is that both developed as well as developing countries are participating. However, this participation is not even, with some regions such as the Caribbean or Africa clearly lagging behind, and with some very strong legal entrepreneurs in the field. For the past 2 decades, this has been, of course, the United States post the US digital agenda, but now there are shifts that are happening, and Singapore really has become the entrepreneur in this area, in particular in striking the new generation of digital economy agreements. And digital economy agreements are really sort of worth mentioning in this context, as they mark really a significant advance in the governance of digital trade, because they are dedicated treaties that address specifically the regulation of the data economy, covering a lot of issues around artificial intelligence, around fintech, law tech. So not necessarily sort of purely trade topics. And as you know, we have so far 6 of those agreements. Some are linked to FTA, some are sort of standalone agreements, such as the Digital Economy Partnership Agreement between Chile, New Zealand, and Singapore. And more of those agreements are in the pipeline Particular mention here deserved the Digital Economy Framework Agreement amongst the ASEAN states, as well as the EFTA Singapore Digital Economy Agreement that is forthcoming. Now, what is important here in terms of the sort of the topics, and you see here on the slides that high and middle countries have agreed upon, in particular in the area of digital facilitation, and we have seen some convergence actually of the treaty language in the area of digital trade facilitation. As to other topics, important topics in the area of data governance, we do not see such convergence. Things like cross-border data flows, ban on data localization measures, the protection, of course, of privacy and national security. Those are issues that are less covered, and we see there a clear contestation between the stakeholder models. And here, of course, we speak about the triad between the United States model, the EU, and China. And this is, of course, clearly reflected in these efforts that we have under the umbrella of the World Trade Organization to move ahead and adopt a plurilateral treaty on digital trade under the Joint Statement initiative. What we also see in terms of the topics that are covered, and I think this is quite interesting, is that in the digital trade chapters, as well as, and even more so, in the digital economy agreements, what we see, what we call it in our analysis, is a sort of a gravitational pull, that a lot of issues get sucked into those, get squeezed into those chapters, things that are not sort of conventional trade commitments. They do not necessarily deal with trade in goods and services, but are issues that are of importance in the regulation of the data economy. And privacy protection is one of those topics that have become now part of this digital trade treaties. The thing is that the real core, the gist of our talk today, is that this gravitational pull has not occurred as to intellectual property rights. Intellectual property issues are very seldomly addressed in digital trade agreements, be it the chapters or the digital economy agreements. There are some important exceptions. Source code is, for instance, one of those exceptions. But here, this is not dealt with as an IP issue, but rather as a ban on forced technology transfer. So we have this disconnect, and if we look at the numbers, what are how are the FTAs dealing with IP? Here, the numbers only partially sort of reflect this disconnect that I have mentioned. In a sense, the numbers can lie here a little bit, because you see that more than 42% of recent FTAs actually deal with IP. However, if one looks at the content of the IP provisions, this is by no means remarkable and has no linkage to the data economy, no linkage to digital trade. It is mostly, the content of those provisions is really about sort of reaffirming TRIPS minimum standards. There is very little sort of innovation and linkage made to digital technologies. We see some of it happening with regard to sort of domestic copyright rules, sort of transfer of domestic rules into the international, into the global landscape. For instance, rules that are dealing with internet intermediaries liability. And this interface is what puzzles us, that this interface is not really happening, especially if you think that not only, as Anthony Taubman, our second discussant today, has argued on many occasions that IP and trade are linked, but also because in the datified economy, this linkage should be even more immediate. We see this because IP obviously matters for the regulation of data. All intellectual property rights matter, copyright, patent, trademarks. But if you look how copyright is protecting or training of AI models, or how trade secret govern algorithms, those are some examples that illustrate this intrinsic linkage. So for me, my part of the talk really is to show you that we have this disconnect, and we are puzzled a little bit by this disconnect in sort of the global landscape of digital trade rulemaking. And Maria now will follow up and explore why we might be facing this puzzle and why we observe such a disconnect. And I hand over to Maria now.
Thank you, Mira. I would also like to express my really appreciation to Professor de Werra for the kind invitation and for Amihud for organizing this, and also to the commentators, and especially to Professor Trimble for inspiring us to write this response, right? So if you go to the next slide, let's unpack why this interface has really not been explored so far. And here I would like just to point to three reasons. I think we are lacking empirical evidence about the interface between data trade and IP, or if there is actually a link between IP and data trade. There is also, in my understanding, there is a lack of knowledge about which intellectual property rights we should be focusing about. We have a narrative of intellectual property rights. Emphasis has been placed so far on copyrights, but it's not the only IPR that perhaps we should be looking at. We also would like to also draw attention to the lack of inclusion of this debate that is happening right now in academic and policy discourse. So if we go to the next slide, please. So we see that there is really a lack of empirical evidence. And by empirical evidence, I mostly refer to the economic indexes that map digital trade, or that cover, that address the openness or closeness of certain countries to digital trade. So some economic indexes, such as the OECD STRI, for instance, only cover measures related to discriminations against foreign firms in two sets of IPRs, trademarks and copyrights, and enforcement procedure related to those two IPRs. No other IPRs are mentioned, and this is a widely recognized economic index for measuring digital trade service restrictiveness. There are also indexes, or well, they were about to become indexes coming out from the same institution, the OECD, showing also that the levels of protection of undisclosed information also matter. And this is work by Schultz and Lippel in 2014 that intended to develop a trade secret index, but actually the efforts, I think, they state and the paper where they were trying to set out the methodology of how to build a trade secret index. And it was actually also later on highlighted by a paper by a USTR official, Linton, in 2015. And then we see that undisclosed information, the protection of trade secrets, actually came more to the spotlight because of domestic legislation actually in the US happening at that time. But we don't have further work on the protection of trade secrets and the link with digital trade. Then we have more recent work regarding to digital services trade, and more generally services trade, highlighting that perhaps patent, copyright, and trademark may matter for knowledge-intensive business services, and those in fact tend to be very relevant services sectors for digital trade. But the caveat is that they might matter only for high-income countries, not for everybody, because they facilitate the delivery of technology and business inputs, and naturally, if a company wants to export to another country or want to export to another market, they will want to see a high level of patent protection, copyright protection, trademark protection. Trade secrets is an aspect that is not covered in this study. It's actually a CGI study from 2024. So the question remains is what type of IPRs matter for digital trade? And I think just to provide some anecdotal evidence here, I was recently made aware that, for instance, the digitalization of the customs procedures and the establishment of single windows for importing products, for instance, requires sometimes that companies submit the documentation electronically, and when they do so, they might sometimes be requested to submit trade secrets. And they are very much against, or they're very trying to calibrate how to deal with this, of course, the facilities that digital technologies offer, but also to provide certain protection for trade secrets, especially when we're talking to cross-border transactions. So next slide, please. So if we go a little bit and look at the policy discourse, and especially what has happened in international organizations such as the WTO, we know that the work programs from 1998 on electronic commerce cover a little bit of IPR. They cover only the protection and enforcement of copyrights and related rights, the protection and enforcement of trademarks, and technology access and transfer of technology. So transfer of technology seems to be a recurring issue in this discourse about electronic commerce and promoting electronic commerce multilaterally, because there has been a submission by South Africa regarding the reinvigoration of the WTO work program that wanted to include again in the conversation the discussion of how to enable the promotion of tech transfer. This should be also addressed. In contrast, if we look at the WTO joint statement initiative on electronic commerce, there is really no mention of intellectual property rights. This is really striking because we are talking about a multilateral institution and the WTO is host of the TRIPS agreement. So it's really striking why this is not happening. There might be several explanations. It's too complicated to negotiate intellectual property rights. Nobody wants to renegotiate the TRIPS agreement, so on and so forth. So we are talking about very two specialized areas, digital trade and IP. And the negotiators behind those areas, they really are not meeting on a forum so far to discuss both of them together. Now, if we look at more regional strategies for digital market integration, we can look at the EU, and that's a very notable example. We know that the EU has issued several directives in the past few years to look, for instance, how to regulate intermediate liability to the Digital Services Act, how to regulate data through the Data Act, and recently how to regulate AI through the AI Act. And IPR is really not highlighted very clear that this matters for digital regional integration of digital markets. But if we want to read the preambles and some contents of some provisions, then two IPRs emerge as they seem to be relevant: copyrights and trade secrets. For instance, the AI Act requires that the data in which models have been trained should be disclosed to check if there is copyright data or not. But the protection of trade secrets should be safeguarded at the same time. So again, we see that these two IPRs seems to be very important for the regulation of artificial intelligence and digital integration. If we go to the next slide, please. If we go to policy documents, this is what international organizations have been releasing their work regarding digital trade. We can see, for instance, that this very landmark report about the 2023 Handbook on Measuring Digital Trade would really helps to try to measure digital transactions cross-border. This is an aspect that really entails a lot of work. It's very notable that we have this now. Has one item within this, the measures the aspects that we should count for measuring digital trade, and one of them is the charges for the use of IP. But it's really not explain what type of IPR, if we are looking at charges for the use of trademarks or copyrights, if we are even talking about technology transfer or licenses of trade secrets, it's really not mentioned there. If we look again at the OECD SDRI index, we see that, for instance, if they do mention trademarks and copyrights, they also mention the exceptions to copyright, but in the sense that it can be a barrier to digital services trade. So what they do, for instance, is to ask the question, does this exception comply with in the international standards for copyright limitations and exceptions, one of those being Article 13 of the TRIPS agreement. And we all know that the TRIPS agreement and the 3-step test was actually interpreted in a very narrow way in previous WTO jurisprudence, which really doesn't go in the same, doesn't follow the same objective that digital trade is wanted to do, to liberalize the flow of data, for instance, by having copyright exceptions that could allow a more leeway for digital or data innovation. It's also notable that perhaps including such an item in an index by a multilateral organization such as the OECD actually is very controversial because this item is not measured towards the OECD SDRI index. Now, if we look at other reports by other multilateral organizations, we have the World Bank 2020 report on the regulation of digital trade. And in this report, IP is part clearly of enabling policies for e-trade. However, the focus here is on intermediate liability and on fair use. And here, obviously, we have the question of why fair use is actually relevant for digital trade, or if we should take this item as relevant for digital trade, because we know that copyright exceptions follow two different types of copyright traditions, and fair use is very much one that is found in the North American and in traditions. So it's really unclear why this was included there to measure digital trade across the globe. So if we go to the next slide, what we see here is obviously a very lack of clarity regarding which IPRs are relevant, what are the appropriate levels of protection, and also what flexibilities should we need or do we need for IPR in the age of digital trade. And regarding the flexibilities, I think there is forthcoming studies this year that really try to see if the flexibilities vary depending of the type of country that we're talking about. And we see that for IPR protection, it really matters. In the case of services, for instance, it really matters depending on the type of country. So for countries that have not a very strong IPR protection yet, it might be advised that they don't increase the level of IPR protection in order, and this is objective, to diversify or increase credit services export. But this is just one study. The second study also talks about this kind of nuanced understanding of what should be the level of protection, right? And this is a CG study that looks at the levels of protection across countries, and they might be beneficial for knowledge-intensive service, but only for countries that are high-income economies, because those are the ones that are trying to secure markets abroad. So far we have the inevitable conclusion that IP and data really go in bifurcated paths. There has not been a customization of IP for digital trade, or frankly, on the other way around. We haven't seen a customization of digital trade for IP, and that is mostly observed as well in the lack of relationship or conflict clause that we observe in between these two chapters, if an FTA has these two chapters. Ideally, there would be a clause saying, in the case of conflict, such chapter should prevail. This is not always the case. So it's really unclear how a conflict will be resolved in some cases. And we evidently see conflicts when we are talking about the flow of data and the protections for trade secrets and copyrights. So next slide, please. So what happens with artificial intelligence? As we all know, artificial intelligence is transborder, and it's kind of a borderless technology, but it's also a GPT, it's a general purpose technology, right? So if we look at the next slide, please. So what we are experiencing now every single day, perhaps if one uses ChatGPT, is that models are training one jurisdiction, and that sometimes with copyrighted data from jurisdiction B, let's say models are trained in the United States with copyrighted data, perhaps from Europe, and are deployed or exported to jurisdiction C, perhaps to Asia, perhaps to Latin America or Africa. So really, we see the borderless nature of AI, and we also see that more and more digital services, goods and services, will include AI as part of the goods and services. So it's really unclear how digital trade will adapt to that situation. One question that we could ask is perhaps whether in this age of industrial programs that are being developed by some countries, can jurisdictions actually compete as hub for AI developments based on the strategic use of IP? And here I just would like to point to the example of Singapore, because we know that Singapore has recently passed, since the year 2020s, have passed exceptions for copyright in text and data mining, and also a kind of a fair use exception in the copyright law of Singapore. And also to note that Singapore is one of the countries that has most digital economy agreements today. But Singapore has not reflected none of these domestic changes at the digital trade, in the digital trade agreements, also in the free trade agreements that it has, and also in the WTO e-commerce negotiations that it leads. So we really see that this specialization is occurring very much intensively for digital trade, but IP really is not figuring out in any of those documents, nor at the multilateral nor bilateral level. But if we consider again that AI is transnational technology, that is a GPT that will actually be the component, probably the main component of many digital goods and services coming in the future, we have to ask if isolating digital trade regulation from other areas of regulation, such as intellectual property in particular, may backfire against AI development and also against the main objectives the digital trade pursues, which is actually the free movement of data for innovation. So if that is the case, let's see what can be done. And we had a list 3 for possible reconciliation. We have WIPO that has undertaken these conversations on IP and AI so far, like since 2018. We have the WTO that is actually the house of those WTO e-commerce negotiations. And we have free trade agreements. WIPO really didn't cover digital trade so far. So really, this is a specialized institution. We don't see IP and digital trade being discussed at the WIPO level so far. And there is no indication that that will happen in the future. At the WTO, that's really a question perhaps for Tony Taubman, why this did happen so far. But if we just follow what is happening, the status quo is really to just have a specialized set of issues called a WTO Joint Initiative on E-commerce that touches only about e-commerce. And perhaps there are political reasons behind that. Having an agreement as fast as possible, it's really important and will actually provide more credibility to the institutions. So perhaps we won't see there also a joint discussion of digital trade and IP. What about FTAs? So with FTAs, perhaps we should really look at this fora, because FTAs is the only fora where digital trade and IP are negotiated at the same time if a treaty negotiates a digital trade and IP chapter. So we go to the next slide, please. If we look at FTAs, what are the possible paths? And this is something that I have been looking at with regards to copyright limitations and exceptions in free trade agreements. And I was very surprised to find a kind of like a light of hope in this realm. So what we have in FTAs is that some of them include a clause on balancing copyright. But when I say some of them, those are really quite important FTAs. So it's a CPTPP, is probably a plurilateral agreement, one of the biggest. RCEP, a very important agreement in the Asia Pacific, and some other Asia Pacific treaties that adopt this language that kind of resembles the fair use clause of the United States. But if we look closely, if we look just at the very first line, we see that every time that we have a clause on the balancing copyright, it just starts with a very non-binding language. So each party shall endeavor to provide something. And when we talk about non-binding language, especially in this context, it's very important to note that sometimes this article will be just after the reiteration of the compliance of the parties with Article 13 of the TRIPS agreement, so the three-step test. So in this sense, the three-step test, this test to provide a roof to limitations and exceptions in copyright is really key to analyzing what is possible with regards to flexibilizing copyright limitations and exceptions, for instance, for data use. So next slide, please. But if we consider FTAs, there is also another aspect. We should consider some geopolitical aspects of this whole FTA negotiation and trade agreements. So we know that the United States is no longer negotiating FTAs since the USMCA. And the US actually was the main proponent of this blueprint for TRIPS Plus agreements in the past, right? And we also know that the United States actually was one of the main proponents of heightening levels of trade secret protection around the globe, for instance, under the US-China Phase 1 agreement. So the question is, what will happen next? And I mean, with the next presidential term. That is an unclear question. We also have these other geopolitical considerations. We have new legal entrepreneurs, Singapore especially, but we have seen really this lack of desire about including those IP issues on the international level. We really haven't seen this reflected anywhere. Now, if we look beyond these new legal entrepreneurs and beyond the proponents of TRIPS Plus standards of protection in the past, if we look at South-South agreements, and this is really filigree tailored, this is a very, very important analysis that should be done, that we are trying to do to some extent, is that we have seen little innovation in IP chapters, particularly we talk about South-South agreements, with a handful of exceptions. And the handful of exceptions, perhaps one example is important, is the Digital Trade Protocol, or the AFCTA, which is being negotiated in parallel to the AFCTA Digital Trade Chapter. So perhaps that is really one example, but most of the agreements, when they are South-South, they reiterate TRIPS standards of protection. They are very short, so they don't have so many provisions. And that so far is the status quo. So next slide, please. So if we're still looking at FTAs, and if we adopt a pessimist approach that nothing will happen, nothing will change, this is the status quo, we have a bifurcated path, and things will remain the same. So what FTAs, digital trade chapters, can do to help counterbalance the exclusive rights against the use of data for AI training, for instance? Here it's very important to remember that there is a lot of innovation going on in those digital trade chapters. And one example of this innovation is provisions included in the DIPA agreement with regards to open government data, public domain, and data innovation. So if we look at those provisions, some of them are non-binding, so are based in the export cooperation clauses. But still, having a public domain provision in a digital trade agreement can free a lot of data for innovation. And this is kind of it's another way of interaction between digital trade chapters and IP. So digital trade chapters will pursue the same goal that they have been pursuing for so many years so far, that is freeing data, while IP chapters are safeguarding this data against, for instance, unlawful use. Another thing to consider is that if this is the way to go, if digital trade chapters perhaps would be some more innovative or more aggressive, particularly with regard to these three provisions, we also have to consider that they most of the time do not prevail when they are in conflict with other chapters. So again, if I have a provision of open government data, on public domain, on data innovation, trying to free data, perhaps then we have to look at the trade secret provisions in other chapters of the treaty, in the IP chapter, and see what are the level of protection offered to trade secret there, and not only level of protection, but also level of enforcement. And again, that's not really good news, because trade secrets now are being included more and more in trade agreements, so perhaps the level of protection has increased going against the very goals of digital trade. If we want to free up data for AI training, I think the most straightforward way to go with regards to this digital trade and IP interaction is to rework the IP chapters inevitably. But one can be only hopeful that this will happen, but all seems to indicate that if it happens, it will happen very slowly. Thank you.
Thank you. Thank you very much for the presentation, which opens a lot of new avenues, and also really is convincing in showing the need to bring together digital trade and IP policies, and with the question that I would have perhaps for discussion later, whether the EU framework to which you alluded might potentially serve as part of a kind of a Brussels effect phenomenon might serve, and specifically the EU AI Act, as a potential model by which we could bring together somehow, but not in a perfect way, but still as a model for bringing together IP policy and digital trade policy. But that's perhaps for later discussion. Now, I suggest that we shall turn to the first of our two commentators, and specifically Marketa Trimble, who, as already mentioned, has been a source of inspiration also for this discussion and for this topic, and who will not only comment but also share with us on the chat what she has written, so that every one of us can also benefit from her writing. So without further ado, I now give you the floor, Marketa. Thank you.
Thank you very much, Jacques, and thank you so much for the kind invitation to join you today. Thank you, Mira and Maria, for the presentation. I am a big admirer of their work because their work, as opposed to mine, is very forward-looking. My work of FTAs was backward-looking, sort of responding to a lot of criticism, particularly in US legal literature, that really vilified these free trade agreements, in particular their intellectual property law chapters. And in my writing, I tried to defend, to some extent, some of the positives that the trade agreements might represent. I am also a big admirer of the data set that Mira and Maria are taking care of, and I'm very much looking forward to the new release tomorrow. So I would like to offer 3 brief comments. One is about the lacking interface of digital trade and IP. Second, about some possible reasons that might be in addition to what Maria covered. And finally, some comments about other possible links that might be missing in the story. So as far as the missing interface between IP law and digital trade, I guess we could think about the IP involvement in digital trade at least at 2 levels. One is the IP rights that concern the, let's call it, the architecture, the network itself, the infrastructure, and what goes into that in terms of intellectual property rights there. And that can be quite broad. We can think of standard essential patents. We can think of certainly trade secrets, copyright, and many other issues there. The second level is, of course, intellectual property rights as they exist in the digital realm in terms of the content that exists in the digital realm. And that could be another layer. There are certainly many links between digital trade and IP. If you think about, for instance, the prohibition against data localization requirements, if you think about rules on geoblocking and evasion or circumvention of geoblocking, if you think about, as Jacques just mentioned, the EU law as a possible template or source of inspiration for what we could do in terms of digital trade and IP, when you think, for instance, about the EU rules on recommender systems, there are certainly interfaces there with trademark law and maybe other types of IP rights. So there are certainly links, and it is, as presented, clear that these links are not being taken care of in the trade agreements. So why are we seeing this lack of IP provisions in the digital trade chapters, or why there's so little connections, and why we see this even lacking aspiration to introduce them? So as already mentioned, there might be some reasons for resistance to enter into negotiations of new IP law provisions. Certainly the lacking leadership from the United States, if we can call it that way, might be one possible reasons. The hesitancy to expand on IP rights has been quite visible at the WIPO. Of course, we do have some successes with agreements at the WIPO, but one might wonder whether those agreements are in fact very narrow and not really representative of major achievements at the WIPO level. I should emphasize there are big achievements for the WIPO and international community, given how little in terms of big IP has been negotiated. So there are certainly great success stories, but again, maybe somewhat disappointing. So what hasn't helped there either is, again, the academic resistance to trade agreements and IP chapters and IP content in those agreements. The second reason might be a certain path dependency. So as noted earlier, complex IP chapters in free trade agreements emulate the TRIPS agreement. The TRIPS agreement was negotiated right at the beginnings of the commercial life of the internet and avoided certain big issues of digital realm already, and of course hasn't had time to be updated in that regard. So there might be some hesitancy to go further beyond TRIPS. There are, of course, TRIPS plus provisions in free trade agreements. That's often the main purpose of the chapters, but they are quite limited, and maybe that's why. The third point I want to make about the missing IP points is about artificial intelligence. When we think about artificial intelligence and intellectual property rights, we often think about them in the sort of input or ingestion of data versus output of the AI. And there are important IP issues on both ends. Some of them, of course, overlap. And when you think about the questions that have arisen so far in terms of IP and AI, in fact, many of them, if not most of them, are actually addressed in TRIPS and in TRIPS plus provisions in the free trade agreements. Infringement, is it an act of infringement to train on copyright protected data? Is it an act of infringement? Is it the reproduction or violation of derivative right? Are there any applicable limitations or exceptions that would cover AI companies' activities? Is there collective licensing that's available? And we have very little on collective licensing in free trade agreements so far, but we have some first provisions on that topic as well. In terms of protection of technological measures, are technological protection measures violated by what AI companies have been doing? And secondary liability, is there secondary liability? So most of these topics are in some ways actually handled in free trade agreements, but at a level that's not detailed enough or not specific enough to give us answers about IP in AI and whether AI is actually legal or illegal in terms of IP rights. Free trade agreements will probably not resolve it until national laws and national legislatures, national courts answer some of these difficult questions. In the meantime, what free trade agreements could do in terms of digital trade would be to clarify the interfaces of national laws, would clarify how the different positions should eventually work out. But at this point, it seems a little premature to think about how countries could agree on a single set of rules for the AI functioning in realm. The route that the EU has taken with the AI Act could be one template, but even there we see that in practice, this might pose some challenges. So those were the three brief reasons that might also explain the lack of IP provisions in the digital trade chapters. And my final note is on other links to other legal issues. Whether we think about data localization requirements or geo-blocking or many other issues, often they are linked to the larger legal environment in a country. Rules of private international law are really important. The way countries delineate the territorial scope of their national law, including national law on IP, is very important. And so at some point, one has to wonder whether free trade agreements will reach some kind of natural limit at which they will actually need the support of other areas of law that are not covered traditionally by free trade agreements, and particularly maybe the support of private international law. For example, when we talk about data localization requirements and the prohibition of those requirements, we quickly realize that it's much easier for countries to agree on such prohibition if they know that they can rely on really functioning judicial collaboration in terms of exchange of evidence, in terms of enforcement of injunctions and other judicial decisions. And without that strong functioning collaboration, it's much harder for countries to agree on a prohibition against data localization requirements. So similarly in IP and digital trade, I wonder whether we might at some point reach a ceiling at which we will need other areas of law to provide a support for further negotiations and further agreement on deeper rules in those areas. Thank you very much. And I will, I will post a link to my latest article that concerns AI and cross-border limitations and exceptions. Thank you.
Thank you very much, Marketa. Perhaps Mira or María would like to quickly react to the very thoughtful comments that have just been made by Marketa before we shall turn to Taubman. Mira, María, any reaction?
I can take up some of the comments. Thank you so much, Marketa. This was really insightful, and I do agree with you on all the points that you made in the sort of three categories as to the lacking interface reasons and this need to have linkages. I particularly agree with you on the part dependence of the fields, and this is true for policy and lawmaking as well as for our academic discussion. So I'm very glad we're having this conversation today. One thing I wanted to mention is sort of an addition is that you mentioned this sort of problems around AI output and input, and that we do have certain rules that are applicable. However, we need to clarify some of those through be it case law or to development in the legal framework. One thing I wanted to add on top of this is that we should also think of artificial intelligence as one of the possible tools for IP management. And we might see this, for instance, in the area of trademarks and domain names, where we have this sort of clashes between, as you know, the protection of trademarks and names and the registration of certain domain names. And there are some new research coming up that basically says that artificial intelligence can solve some of these problems, and potentially this can be included then in the digital trade chapters as a sort of a solution rather than, you know, clarifying how intellectual property actually applies. And I do agree with you completely about this need to have connection with other fields of law. And I think in a way we are observing this already happening in the digital economy agreements or in the digital trade chapters, because as I mentioned before, they're not so much about trade issues. It's not really about, you know, how we trade goods and services. It's really about a sort of they provide a little bit of interoperability between domestic regimes and different fields of law within those domestic regimes. So indeed, this might expand or extend over time so that this sort of interfaces do work better. And I'm going to stop here, and I'll be happy, however, to address Jacques' comment on the Brussels effect later on.
Maybe I could add on the one quick. I just wanted to know that, again, this question of interoperability is so important because we observe that a lot in the cross-border data flows, right? We are trying to seek interoperability. This is a question, however, that is being addressed not only in trade agreements, but also in the forums around trade agreements where negotiations happen, right? This is a question that happens, that it's been addressed in the OECD, the G7, the G20, all the work that Japan has undertaken in those forums to address interoperability with regards to cross-border data flows. But that requires policy leadership, and it requires a country pushing this issue forward and include it in negotiations. And that is indeed the case of Japan. I think they have been the main proponents of this issue, also with regards to the data free flow with trust, data free flow with trust. And I just wanted to ask, perhaps, yes, a follow-up question will be like, what happens in between until we get all those court rulings at the domestic level to clarify whether this is protected by whether AI outputs are infringing or not, or whether this is even protected by patents, patent law. What happens in between? Do we seek just a level of cooperation and discussion? Or perhaps even if nothing happens, that means that we don't need to really to address this gap internationally because things are working perfectly fine otherwise. So that's a question that I have.
Thank you very much. We'll keep that question also open for future reaction. But now let us turn to Tony Taubman, who, as mentioned, will act as our second commentator. And thanks, Marketa Trimble, for sharing her paper on the chat, which is available to all. But now to Tony, and thanking him again for joining us in the middle of the night, as mentioned earlier. Tony, you have the floor.
Thank you very much, Jacques. I'm delighted to be joining this panel. I'm also a member of the fan club of the wonderful data set put together by Mira and María colleagues at Lucerne, and their tremendous analysis, which we've heard already. Likewise, Marketa's path-breaking study of IP and FTAs, as well as the work of the Digital Law Centre, and Jacques, you as a thought leader in this area. So I'm delighted to join you. As a card-carrying member of the fan club, it's tempting for me just to go through everything I agree with what's just said, but I'll try and branch out and take up some of the issues that have been put on the table. The central one, I think, coming from the main presentation, is this bemusing disconnect between IP and digital trade. It's something that has fascinated and tantalized me personally for some time. I think if we look at the FTA context, the idea of path dependency comes up here too. I think to some extent it's an artifact of the very structure, the institutional framework of the negotiating process of FTAs, where these chapters are typically negotiated by different teams with different constituencies, different areas of expertise, different formal responsibilities. And I think it's ironic that really we're seeing a rerun of the classic situation with IP and trade, in that, if you like, real trade negotiators, whether it's in the analog world or the digital world, tend to look at IP somewhat askance, as a kind of a regulatory intrusion on the flow of trade. This is, and I think, to take up the point about what about in the multilateral context, in the WTO. I mean, I personally have sat in the TRIPS Council for some time, wondering why, with all these developments, members are not negotiating, or at least discussing, the evident fact that there is a transformation in the relationship between IP and digital trade in the last 30 years. I think there, to some extent, it's I think it's the point Maria made, that there's concern about the existing agreement unraveling, that rather than a forward-looking discussion about the new nature of the relationship between IP and digital trade, a concern that it would just lead to ever more pressure to weaken IP protection, to open up wider exceptions and limitations, and so on. I'm less convinced that's the case, because we do see strong interest from across the developing world in the positive opportunities for developers, creators in the developing world to benefit from, in particular, copyright in their works that now may be distributed, marketed indeed, on new platforms around the world. So there may be less of a zero-sum approach, but that's just my supposition. Interestingly, there is another way into this issue at the moment. That is the long overdue Article 71 review of the TRIPS agreement, and possibly that might lead to a necessary conversation about the interface between IP and the opportunities of digital trade, the development dimension of digital trade, in a way that may provide that reassurance that a discussion in this area doesn't have to be zero-sum, doesn't have to be arguing about exceptions and limitations as such, but rather a forward-looking positive agenda. It is something, and I think Mira pointed out, I take every opportunity I can to point this out, that so much digital trade is trade in IP. This is not a novel observation. This is, in fact, something you'll see in an early paper submitted by Indonesia and Singapore at the beginning of the WTO program on electronic commerce back in 1999, saying, by the way, in between trade in goods and trade in services, there is such a thing as trade in IP that we should be thinking about. And that's literally 25 years ago. So it's not a novel concept. But since then, we have seen this develop in practice. And it is the fact that so much of the trade we're talking about, trade in what might be called digital products or downloads, is structured legally as an IP license. And if you read through those conditions, when you click through the 43 pages of terms and conditions on these digital platforms, you'll read apps made available through the App Store are licensed, not sold to you. That is an IP license, a very limited IP license. And the difference now is that we are seeing countless billions of such transactions globally today. And this constitutes a very significant area of international commerce, particularly for the content industries, the software industries, but also a remarkable opportunity for creatives and developers in the developing world who in the past have not had serious workable access to global markets. So with TRIPS now 30 years of age, it's probably time to really consider in a more systematic, integrated way the interrelationship between IP and digital trade, with this the fact of this transformation having taken place. But indeed, as Mira and Maria and indeed Marketa have pointed out, this disconnect is structurally apparent in the FTAs, and I would simply refer to the implications of this. An example would be the Canada-EU CETA, where there's a reference to online delivery. Delivery is defined as a computer program, text, video, image, sound recording, or other delivery that is digitally encoded. Now, if you've spent 5 minutes working in the area of IP and copyright, these are copyright works in virtually any jurisdiction. But there is a separate chapter on IP, and this agreement has a very typical non-conflict clause. In the event of inconsistency between this chapter and another chapter, that other chapter prevails to the extent of the inconsistency. There is a chapter on IP, a separate chapter. So we have this curious paradox of a chapter dealing with trade in copyright works, nonetheless anticipating potential conflict with the parallel chapter that defines copyright, or the scope of copyright, copyright limitations and exceptions, and so on in the digital context. That to me is a symptom of this deeper uncertainty and confusion that the paper points out, I think, quite brightly. Similarly, the other great cluster of FTAs dealing, in a sense, with digital trade, the US FTAs, they don't refer to deliveries or online deliveries, but digital products. But once again, if you read through those agreements, there's a reference to the author, performer, producer, developer. Once again, a clear signal that we are at least implicitly thinking about copyright works as the very subject of trade. And I think this is what's fascinating about these developments. We have seen the very notion of trade. We don't have a definition of trade as such in any of the WTO agreements, in any of these agreements at all, in fact. And we've seen the very character of trade being redefined before our eyes in these emerging forms of digital trade. Just to touch on the point of the wider IP context, and indeed it's not enough to get immersed in purely in the copyright aspects. One interesting sideline I would point out, if you look at the WTO text, the joint statement text on electronic commerce, there is a curious overlap with the broader field of IP in that there are provisions on consumer protection. And I would argue that there is a parallelism there with the area of unfair competition, and in particular Article 10 bis of the Paris Convention, which does provide for a certain degree of consumer protection, quite consistently with the WTO text. Once again, I'm certain that was not intentional. It wasn't structured that way, but it's a reminder of the need to look beyond the boundaries, our disciplinary or our regulatory boundaries to see these more positive linkages. Another point I would make there, and I will conclude shortly, is this is an area for increasing attention to the interaction between competition policy and intellectual property. I personally don't think that the challenges of the digital economy and the challenges, the possibilities of the platform / download / streaming economy necessarily has to be dealt with through ever more precise definitions of exceptions and limitations. I think the CTPPT statement, which is like a copyright riff on Article 7 of the TRIPS agreement, I think that's the right kind of thing. It sends a clear policy signal. It's a benchmark, but the trade negotiators really don't have to get into the sort of push aside the job of the legislature and even the judiciary in working out how to apply these principles in ever-evolving, rapidly evolving situations, as we see, to quote Article 13 of TRIPS, the normal exploitation of works rapidly evolving in ways that are really impossible for the legislator, let alone the trade negotiator, to predict. I would conclude just with some quick points to reflect on something that again has come up. What is rulemaking, even trade negotiations in this area for? And others have pointed out, is this really about simply freeing up trade in digital products, or is it, as has often been mentioned, a way of working through domestic regulation and, if you like, imposing that on one's trading partners? I think the point the real opportunity here, and this is getting beyond the zero-sum thinking that dogs all trade negotiations, but particularly in this area, the idea that there is an enormous opportunity here, finally, for creators, for developers, for innovators, even in the most resource-poor environments in the developing world that have been typically structurally excluded from international trade and its benefits. There's tremendous opportunities here. There are real issues about the dominance of certain platforms for making digital content available. And at a time when there's a broader debate about not just non-discriminatory trade or freer trade, but also fairness, and this is a theme in the reglobalization discussion. It's time to think about this in terms of the platforms that support trade in digital content and what can be done, whether through norm-setting means or development support and cooperation, or simply policy dialogue to make for a fairer set of global platforms so that creators, innovators anywhere do have fair and equitable and effective access to global markets. I think there's a great deal of work that can be done there without being too utopian about it. And this does involve also considering the competition policy dimension. I think that's one of the ways into it, but also just the kind of open discussion about national experience, whether there is a Brussels effect, also looking at the regional context. I know I'm out of time, but I just quickly wanted to mention on artificial intelligence. I'll resist the temptation, like everyone else on the planet, to pontificate endlessly about artificial intelligence. I would say, however, that I don't see it as necessarily something that needs to precipitate a redrawing up of norms at the international level. Here I depart slightly from Maria's comments. I think the three-step test, even as it's understood in dispute settlement in WTO litigation, I think it's quite accommodating. I think it is a good benchmark for a fair and balanced approach. We have these further insights from the CPTPP, just in terms of a broader sense of the normative framework. And these concepts of normal exploitation, these concepts of prejudice, unreasonable prejudice, and so on, these are exactly the kind of issues that the courts are crunching through at the national level. And I think that's, like it or not, that's where a lot of the norm-setting pace will be, rather than at the international level. So I do think that the international framework is adaptable, is much more able to respond to technological change than we may assume, even though it was indeed drawn up squarely in the analog era without any anticipation of the challenges of the digital framework. But I think it is a more supple and forgiving, adaptable framework. Finally, I should say that in 2 days' time, I think the WTO will be releasing a report on artificial intelligence and trade. And as part of that, my former colleague, Wolfmeier Ewert, is moderating a panel discussion exactly on IP and artificial intelligence today. And so that would be a far more productive conversation than my quick remarks now on this topic, but I think that would be unmissable. So thank you very much. Wonderful to join you for this conversation.
Thank you very much, Tony. Actually, I will be on that panel at the WTO on Thursday. I'm sharing the link because it's a hybrid event, so everyone can join. And I hope that it will be an interesting discussion, continuing our discussion today. Perhaps again, turning to Mira and Maria, if you have reaction, and as you were mentioning earlier, Mira, if you wanted to react on that Brussels effect to which Tony also alluded a few seconds ago.
Yeah, thank you so much, Jacques. Thank you so much, Tony. I'll be very brief and basically really agree with you on the important point that you mentioned, that a lot of the digital trade really is trade in IP. And you mentioned quite rightly the IP licenses there. And I also agree with you on the sort of the complexity that we have of these very fragmented legal frameworks. But on a positive side, you can say that there is a lot of work for lawyers and for us academic to somehow explore these overlaps that we have between IP and other chapters in the trade agreements, be it digital trade agreements or digital economy chapters. And we forgot to mention here that, for instance, a lot of the rules that we have, the commitments on non-discrimination of digital products, they do exclude intellectual property. So there again, there is this sort of interplay between the provisions. And we also have the interplay between the sort of the international commitments and the national regimes. And the IP licenses that you mentioned, they most probably are based on the applicable national law. So that brings another complexity, as well as the complexity across the different legal fields. And you rightly mentioned there competition. So thank you so much for your comments. And coming back briefly on the question around the Brussels effect, I think the EU is, of course, a legal entrepreneur, especially in the area of the European Union itself, and it's doing a lot as to issues of data governance. You mentioned the Data Act, but there is also the Data Governance Act, which is about sort of the sharing of data within the EU community. What we have seen so far with the EU example is that they do interface with whatever they're doing internally with the trade framework as far as privacy protection, so personal data protection is affected, but not so far with the other instruments that we have in this broader data governance framework, including the AI Act. So we're going to see in the coming years whether such a sort of interface is going to occur. We see some elements of it already happening in the EU-Singapore digital economy agreement, which is not finalized yet. As with the Brussels effect, I think the Brussels effect is occurring through sort of two channels. On the one hand, it happens because companies must comply with EU law because of the EU law's extraterritorial effect. And we also see this because a lot of countries are simply copying what the EU is doing. However, this copying is not happening in a uniform way. So the GDPR definitely has been copy and pasted in a lot of jurisdictions. What is happening with the AI Act is not necessarily the same. We see the adoption actually of rather different models in different jurisdictions. So I think this Brussels effect is occurring, however, with different speeds as to the different areas of data governance. And overall, it still does not somehow address this fragmentation. It's probably not going to be the model. The EU model is not going to diffuse in a uniform manner.
Thank you so much. Maria, would you like to react?
No, I think everything has been covered. Perhaps just with regards to Article 13 of the TRIPS agreement, this is such a complex and debated issue, but perhaps a good clarification of what are the limits and in international law of what can actually countries do to facilitate this AI innovation with flexibilities for copyright or no. That will be very much welcome at some point. I know it's an issue that predates very much the AI hype, but it will be really interesting and necessary perhaps to count with the guidance on that.
Thank you very much. May I ask you, Maria, because you referred, and also to you, Mira, to this concept of new legal entrepreneurs, and you referred to Singapore, but did not really expand on that. I was curious if you could perhaps share examples also in terms of what might be the way forward in terms of guiding us into what could be potential models for future developments.
I mean, we sort of use this concept really to show the shift from the US to perhaps new rule makers in the area of digital trade governance. And with Singapore, what is really sort of remarkable is that it has been part of essentially all digital economy agreements. It's the driving force behind these digital economy agreements, except for the one between the US and Japan, the Digital Technology Agreement, which is not really also as innovative as the Singapore model. And in those agreements, what really happens is that they somehow accommodate some of the sort of standard CPTPP digital trade commitments. But on top of that, there is so much going on in the area of, let's say, digital inclusion, digital identities, digital innovation, low tech, fintech. So a lot of there are soft cooperation provisions, but they try to explore where cooperation can really happen as to the regulation of the data-driven economy. And Singapore has been leading really the way.
Thank you. Thank you very much. Marketa, would you like to react to what Tony said, or to other comments which has been made?
Thank you very much. Thank you, Tony, for your comments, particularly on the issue of AI and legal rules for AI in trade agreements. I agree that the three-step test is flexible and provides an important and established framework in international copyright law. I think it's also interesting to see how the rules have evolved. So, for instance, when you think about the text and data mining exceptions in the European Union, in Japan, I think in both places we see, I would call it a certain backpedaling on the content of those exceptions, right? So in both places we see a reinterpretation attempts of those rules to show that not all AI will be covered by that, certainly not generative AI. Let me just say very briefly to Maria's question about how come we don't see more activity on these AI rules and more aspiration to put those in trade agreements. And that's a very interesting question, because if we consider that the major, perhaps arguably strongest players in AI development are US-based companies, I think it makes perfect sense that they are not in a hurry to initiate or get involved in AI copyright, at least AI-related rulemaking or law setting at the international level, because until at least now, and until January for sure, they have had not much success at initiating and affecting legislation at the national level. So US Congress was not really able to pass any major legislation at all, and certainly not any complex and comprehensive legislation such as an overhaul of copyright law for AI development. So they have to rely on courts moving the law forward. And in this environment, it's very tricky for them to try to get involved at the international level, because frankly, they don't know what to lobby for at this point, right? Because they need to first figure out what the law will be in the US, and there they need to influence the courts, right? At least that's what the situation is now. And as you mentioned, we will see whether the elections will change anything about that. Thank you.
Thank you very much. Time, even though the discussion has been quite intensive so far, are there reactions, comments, questions from the audience at this stage? So, which I don't see happening, but perhaps one general comment and perhaps a question is to realize when I was listening to you and to the point that you made is that when we focus and discuss as we do about the missing interaction between IP and digital trade policies, I have the perception that perhaps the problem is even worse. Because when I look at various of these EU instruments, actually it's a mixture, or perhaps not sufficiently well and carefully thought framework, which is supposed to govern certain IP facets and certain digital trade facets. But we have, and that's my point now, to I think add in the discussion other areas which are of key significance, one of which has been already mentioned by Tony Taubman, and I think we all agree on that, competition law. But what about consumer protection? in many of these cases. What about contract law? As we know, this is an area, and we refer to licensing agreements. So this is governed by general terms and conditions, which might be unfair, and if yes, under what condition? And what about, as we all know, the potential parallelism that may exist or not, but at least to be discussed for personal data protection, because when you scrape data, you may scrape IP protected content, but you may also scrape potentially personal data. And I think would obviously make sense as a matter of principle to have some kind of a certain level of policy coherence in order to ensure that there is a adequate level playing field which balances sufficiently correctly the respective rights and obligations of the stakeholders. So I think without sounding too pessimistic, I think it's a challenging mission, but we definitely have to also look into the discussion today at ways how to integrate better the two areas on which we've been focusing today. And one other quick comment is about the way to do so. So do we need to change the international regulatory framework? Maybe not, because it's flexible, but I have just with me, I haven't really had a chance to read it carefully, but the first draft general purpose AI code of practice that has just been released at the EU level, and I'm interested not only by the content, but also by the format. We will now enter a world of code of practice for covering certain of these facets with all the ensuing consequences of norm setting, which is what you mentioned earlier, Tony. So I think it's definitely an interesting time, and also definitely an interesting time for legal entrepreneurs and legal policymakers and thought leaders on all of these issues. So I think we should progressively wrap up. So I wanted to give the floor to our speakers first. Maybe if you have a last word or comment or reaction, Mira and Maria.
Just very briefly, thank you so much to everyone for this really interesting discussion. We did the whole 1.5 hours. I did not expect this. Yeah, and I printed this code of practice. I'm going to read it now on the train when I go back home. But maybe one thing that you mentioned about all these EU acts, and that they're not necessarily working very well together and the interface is not there. Perhaps one thing that helps or is going to help over time is that we have this intensified transparency obligations in all these documents. So we're going to see actually how things work, be it with regard, to power, to terms of use, consumer practices, personal information that might be in some of the training data, etc. So I think this is something that we also have in free trade agreements, and something that Marketa has also written about as a positive TRIPS Plus development. So just on a positive note to end this conversation from my side.
Thank you very much, Maria. Any final comments or reactions?
I think I would just leave it in that positive note. Also on the positive side, that TRIPS Plus agreements can actually have good things.
Great. Thanks so much, Marketa. Perhaps another.
Thank you very much. This was really interesting and inspiring, and I'm delighted that Mira and Maria have been writing about this topic of intersection of digital trade and IP, and I'm looking forward to reading more from them on that.
Thanks very much, Marketa. And Tony, before you can go back to sleep, hopefully, any final reaction?
I would just put in a plug, two cheers for multilateralism. I think we are seeing increasing fragmentation in the normative framework, even within the same FTAs, let alone looking at the broader complexity. And I think sometimes we need to almost need to have that kind of overload of complexity and fragmentation for people finally to accept that multilateralism can be a solution. I think that's we've seen cycles of this in previous IP lawmaking, going back to the original Paris and Berne conventions. So it will take some time, but I think it will become necessary, given that we are talking about seamless global platforms for trade in digital content that do transcend national jurisdictions, but we're talking about rights that are defined under national jurisdiction. So that contradiction is there. I think ultimately a multilateral solution will have to be found. I think it's a fair way into the future, which is why this kind of work, this kind of legal and policy analysis is going to be so important, so that when the time comes, we have the right ingredients. So fantastic to have this work proceeding, and I think the work done by our presenters today is at the forefront of that. So thank you.
Thank you very much to all of you. So in order to reach multilateralism, we need multilateral discussion, and we had a wonderful discussion today. Thanks to all of you. So thanks very much to our speakers, to our commentators, and we very much look forward to welcoming you to a next session, hopefully to present next iterations of your respective works. Let me also thank and express our gratitude to the team at the Digital Law Center who has been organizing this, and particularly to Amir Joseph, who has been organizing this session with me for some time now. So many thanks to all of you, and wishing you a good rest of the day or good night for those of you, including you. Thanks to all, and wishing you a good night. Bye-bye.
Bye. Thank you, everyone.
Thank you, Vera.
Bye-bye.
Thank you. Bye.